numbers of speakers, and because we have delays in the program of work, in the speaking time limit for this clustered interactive dialogue will be reduced to 2 minutes for all speakers. Now I invite Madame Gabriela Naul to present her reports. You have 15 minutes for the presentation, Madam Special Rapporteur.
Thank you, Mr. Vice President, distinguished delegates, ladies and gentlemen. It is with great honor and emotion that I'm addressing the Human Rights Council for the last time as a Special Rapporteur on the independence of judges and lawyers. I'm presenting today my annual report, thematic report, which addresses the protection of children's rights in the justice system, as well as 4 reports on country visits I carried out to Qatar, the United Arab Emirates, Tunisia, and Portugal. I wish to reiterate my gratitude to the respective governments for their invitations and cooperation. Distinguished delegates, in this year's thematic report, I examined the essential role that must be played by judges, prosecutors, and lawyers in upholding children's human rights and applying international human rights norms, standards, and principles relating to children at the domestic level and in compliance with the state's international human rights obligations. Every day throughout the world, countless children come into contact with justice systems. These systems are often not adapted to the needs of children, and as a result, far too many children suffer adverse consequences at the hands of a system that disregards or even directly violates their fundamental human rights. I endeavor to expand my analysis beyond the notion of juvenile justice so as to reflect the diverse experiences of children when they encounter the justice system because they are victims, witnesses, or parties to justice proceedings, or because they are in conflict with the law. In all these aspects, children have special rights, needs, and interests that must be considered. The report is divided in 5 parts. In the first part, I laid out the legal framework and fundamental principles upon which I based my analysis. The second part addresses access to justice and legal aid from the perspective of children. Not only do children face the same obstacles as adults to access justice, but they also encounter challenges and barriers directly resulting of compounded by their status of minors. In the third part, I present an overview of the safeguards necessary to respect, protect, and fulfill children's rights at the different stages of judicial proceedings. Despite the abundance of international treaties, rules, guidelines, and principles that exist to protect children's rights, the treatment of children in judicial proceedings, both civil and criminal, is unsatisfactory and, if not, acceptable. The administration of justice, whether in criminal, civil, or administrative proceedings, must therefore be guided at all times and in all matters concerning children by the fundamental principles of non-discrimination, the best interests of the child, the right to life and development, and the right to be heard. Part 4 examines the necessity to provide for alternatives to judicial proceedings. Because of the trauma that can result when children go through criminal proceedings, it's essential that alternative mechanisms be put in place and systematically considered whether to complement such proceedings, thereby mitigating trauma or to replace them. Finally, in Part 5, I once again underline the essential need for quality and specialized education and training for judges, prosecutors, and lawyers, creating and strengthening training and capacity building programs on international human rights law and jurisprudence, in particular on children's rights, for all justice operators is an important requisite for a competent, independent, and impartial judiciary and legal profession that this is in a position to deliver justice to children. Ladies and gentlemen, despite the quasi-universal ratification of the Convention on the Rights of the Child, children still count among the most vulnerable to human rights violations and other types of abuse. For this reason, the importance of child-sensitive justice, justice that respects, protects, and fulfills the rights of children, cannot be overemphasized. Judges, prosecutors, and lawyers can influence the future course of children's lives. As a result, they have a great responsibility towards children and administration of justice that fails children ultimately also fails society. Distinguished delegates, I visited Qatar from 19 to 26 January 2014. Qatar has come a long way in a short time with respect to developing its justice system. Qatar's permanent constitution, which entered into force in 2005, includes provision on the separation of powers and the independence of the judiciary. In spite of progress witnesses and welcomed, I remain concerned that the challenges and shortcomings identified in the report undermine the authorities' positive reform efforts to develop a justice system that is in line with international standards and human rights obligations. In particular, I am concerned by violations of due process and fair trial described to me during my visit, and the consequences such violations have on people's lives and human rights. I am further concerned that despite recent efforts by the authorities and the National Human Rights Committee, the obstacles encountered by vulnerable sectors of the population, in particular migrant workers, to access justice seem to be almost unsurmountable and are compounded by the kafala system. These challenges and shortcomings must be assessed and addressed in a timely fashion in order to bring the administration of justice of Qatar in line with international and regional human rights standards. I further urge the relevant authorities to take concrete measures to reform the kafala system as publicly announced on various occasions, and to redouble efforts to facilitate migrant workers' access to justice. I commend Qatar for its engagement with special procedures and hope it will continue. From 28 January to 5 February 2014, I visited the United Arab Emirates. The justice system in the United Arab Emirates has developed an elaborate and complex court system in a relatively short time frame. Yet, despite some remarkable progress and modernization, I am worried that some of the challenges and shortcomings identified in my report are serious and affect the delivery of justice, the realization of human rights, and the public's confidence in the judiciary. I am particularly concerned at the reports of serious breaches of fair trial and due process guarantees, especially in case of alleged state security-related offenses. Most of the people accused of state security crimes are arrested without a warrant, taken to secret detention facilities where they are kept incommunicado for days, weeks, or even months, subjected to torture and/or other forms of ill treatment. Their access to legal counsel is extremely limited. In addition, these cases are considered in first and last instance by the Federal Supreme Court, denying defendants their right to review of the conviction and sentence by a higher tribunal. I am extremely concerned about the harassment, pressure, and threats to which some lawyers are subjected in breach of their independence, especially when they represent clients accused of state security crimes. I urge the authorities to continue strengthening its judiciary and to reform the legal framework in order to better guarantee and protect the independence of judges and lawyers, and bring the administration of justice at both federal and local level in line with the human rights obligations of the state. I encourage the United Arab Emirates to continue such engagement with special procedures. Mr. Vice President, I visited Tunisia from 27 November to 5 December 2014. The purpose of my visit was to examine the situation of the justice system since the revolution of 2011, the efforts made during the transition to start reforming and strengthening the independence of the justice system, which used to be controlled by the executive power, cannot be overstated. The achievements of the transition, the new constitution with regards to the justice sector now need to be translated into reality. A lot of work was left to legislators who have to revise existing laws and draft new ones to operationalize the constitutional vision of an independent, impartial, and competent justice system. Recent concerns were reported to me about the Parliament's adoption of the law on the Supreme Judicial Council of 15 May. According to the most recent information received in a decision taken on 8 June, the Provisional Body for the Control of Constitutionality of Draft Laws, which was sized by members of Parliament, indicated that the adoption procedure of the law, partly because the Parliament did not consult the Provisional Judicial Council, and some of its provisions were in violation with the Constitution. In such a context, I wish to call upon the Parliament to seriously consider the recommendations contained in my report and to hold broad and open-ended consultations with the law will be resubmitted for its adoption. Transparent and inclusive consultation process are essential to contribute to building trust in the democratic institutions Tunisia is establishing and thereby strengthening the rule of law. Distinguished delegates, I carry out my last visit to Portugal from 27 January to 3rd February of this year. Portugal relies on a solid legal framework protecting the independence of judges, prosecutors, and lawyers. The overall positive perception of independence of the judiciary in the country is possibly one of the most important achievements of the transition to democratic rule in Portugal, and certainly shows that legal commitments are mostly reflected in practice. My visit took place at a moment of intense debate on the functioning of the justice system as the government was implementing a major reform in the administration and distribution of courts adopted in 2014. At the same time, the country is coming out of a major economic crisis that also has affected justice actors and institutions as public resources become scarce. In this context, it's important to highlight that the independence of the judiciary is not a static achievement secured for good by the adoption of adequate norms and practices. Ensuring the independence of the judiciary requires permanent monitoring and identification and tackling of the new problems faced by judges, prosecutors, and lawyers, as well as those who come in contact with the justice system. Concerns were brought to my attention regarding the pace of implementation of the recent reforms, the security of the electronic system, the legal instability generated by frequent amendments to legislation, access to justice for vulnerable sectors of the population, and the protection of defendants' guarantees. These are areas where improvements can definitely be made, and I trust that the authority will look at my recommendations carefully. Mr. Vice President, before concluding my intervention, I would like once again to call upon the distinguished members of this Council to unequivocally condemn all instances of reprisals against individuals or groups of individuals for their cooperation with United Nations, its representatives, and mechanisms in the field of human rights. Let us not forget that behind the abstract concept of reprisal as understood by the United Nations are women, men, and children who suffer unacceptable violations of their human rights. Distinguished delegates, I can say today that during my 6 years as a Special Rapporteur, I have stayed true to myself, to my independence, and to my mandate that was entrusted to me by the Council. During these 6 years, I have often felt humbled by the enormity of the task before me, and I would like to thank all those who contributed, one way or another, to my work as a Special Rapporteur. I'm proud of what I have accomplished, yet I would like to underline that much more needs to be done. Indeed, while I have observed many positive developments around the world, I also have to report that I have witnessed deterioration, sometimes to an extremely concerned extent, of the independence of the justice system in different places around the world, including increasing harassment, threats, and attacks against judges, prosecutors, and lawyers simply for discharging of their functions. We cannot remain complacent. Progress achieved is at risk if you do not constantly monitor, assess, and strengthen the independence of judges and lawyers, and take adequate measures when warranted. I call upon this Council to renew its attention to issues related to independence of judges and lawyers, and to support my successor in the important task that waits him or her. Thank you for your attention.
I thank you, Madam Special Rapporteur, for your presentation. And the list of speakers is now closed. And now I invite Mr. Daniel Spouros to present his report. You have 12 minutes. Please.
Mr. Vice President, Excellencies, distinguished delegates, ladies and gentlemen, it's my pleasure to be here with you today. As I took office in August last year, this is the first time I am addressing the Council in the capacity of the Special Rapporteur
Lucknow in the period from the 28th of January to the 5th of February 2014, out of its firm commitment to further promoting and protecting human rights. Being a member of the Human Rights Council, the UAE is particularly committed to cooperating with the mechanisms of the Council. This visit came in implementation of a recommendation we received during the second round of the UPR in 2013. The UAE has engaged with the Special Rapporteur in a constructive dialogue based on cooperation on the independence of the judiciary in the UAE. It is noteworthy that the Special Rapporteur commended our constructive cooperation during her visit. She also noted the progress and achievements made in a short span of time by the United Arab Emirates. We will take into consideration all the valid recommendations and will work on improving our legal and judicial systems. The United Nations, the UAE legislation guarantees the judiciary independence as per Article 94 of the Constitution, which states that judges shall be independent and shall not be subject to any authority but the law and their conscience. Among the other safeguards is that judges may not be removed during their service. Vocational training is also being provided in the field of human rights to judges and prosecutors. The legislation and the Constitution of the UAE contains a number of safeguards that ensure fair trials based on notably the principles of the presumption of innocence and legal aid counsel. Torture and degrading treatment are prohibited according to the Constitution, to the law, and being with a UAE a party to the UN Convention Against Torture. Prisoners also receive regular visits by the UAE Human Rights Society, which is a non-governmental organization that monitors the conditions of detention, provides public reports about the results they achieve. UAE also rates high in the independent indicators in terms of rule of law and the judicial independence. The World Justice Project rated UAE as 27 out of 108 states in terms of the rule of law for 2015. UAE also ranked the 22nd out of 144 states in the Global Competitiveness Index for 2014 to 2015 in terms of the independence of judges. However, the report contained erroneous claims that were depended on in order to jump to certain conclusions and recommendations without specifying the criteria used in assessing the sources and information used in a manner that renders it reliable, nor providing the names of the persons concerned or the dates and details of specific cases. Lack of details on such claims makes it practically impossible for the government to investigate such incidents. We therefore call upon the delegations to consider our detailed response on the different other statements of the report in the form of issued in the form of a document, an official document. We understand also that the promotion of human rights is an ongoing process. That's why we are working on following up the implementation of the 100 recommendations accepted and the 7 additional recommendations that we accepted in the second round. In conclusion, we affirm that we are totally committed to working continuously and constructively with the Special Rapporteur in her discharge of the mandate, and we will look seriously into the recommendations she advanced in the report, being part of our ongoing efforts to promote our judicial system and promote the human rights principles and the laws adopted in this respect. Thank you.
Thank you. Regarding the report of the Special Rapporteur on the right to health,
Judicial Sector, thank you.
Floor to Al Salam Foundation.
Madam Vice President, Madam Rapporteur, Al Salam Foundation with Americans for Democracy and Human Rights in Bahrain would like to thank the Special Rapporteur on the Independence of Judges and Lawyers for her recent report following her mandate's country visit to the United Arab Emirates. We welcome her comprehensive report on the UAE justice system and fully support all 42 recommendations contained therein. In this report, your mandate raised core concerns over the independence of the Emirati judiciary, including concerns regarding the extensive influence of the executive in the judicial process and the amount of pressure and influence the executive and prosecution can play over the large number of non-Emirati, short-term, contract-based judges employed by the Emirati judiciary. Your report stated that, quote, reports and allegations of pressure exerted by members of the executive, prosecutors, and other state agents, in particular members of the state security apparatus, are of serious concern to the Special Rapporteur. She is especially concerned that the judicial system remains under the de facto control of the executive branch of government, end quote. In line with this assessment, we would like to raise our concerns regarding the reported roles of the Royal Court and local rulers' offices in interfering in the administration of justice. This process was recently reported by the U.S. State Department's 2014 Human Rights Report on the UAE, which stated that, quote, by tradition, the local rulers' offices, or diwans, maintain the practice of reviewing criminal and civil offenses before they referred cases to prosecutors. They also reviewed the sentences judges passed, returned cases to the court on appeal if they did not approve of the verdicts, and had to approve the release of every prisoner who had completed a sentence. The Diwan's involvement led to lengthy delays prior to and following the judicial process and lengthened the time defendants served in prison. Authorities considered a Diwan's decision in any court case as final, end quote. While not addressed in your report, was the practice and modalities of such executive interference explored during your mission to the UAE? And if so, how does your mandate recommend combating such customary practices outside the former judicial structure? Thank you.
Thank you. Development, Innovations and Network has the floor now.
Merci, Monsieur le Président.
Thank you, President. We support the Special Rapporteur's conclusions on the independence of judges regarding her visit to the United Arab Emirates, where around 200 prisoners of conscience of various nationalities are now in jail and are often victims of unfair trials, torture and mistreatment. We regularly record many cases of enforced disappearances, arbitrary detention, harassment, mistreatment in prisons, including the famous Hazin prison, as well as systematic torture, restrictions of the freedom of expression and assembly. Militants and lawyers are threatened every day when doing their jobs. Mohamed Rocha, a renowned lawyer who was fighting for greater justice in his country, was sentenced in 2013 to 10 years in prison. There's also the case of Osama Najjar, sentenced to 3 years in prison in 2014 on charges linked to his Twitter account on which he was defending human rights. He was tortured and prevented from having health care. He did not learn about his sentence in the court, but in the judge's office, in the absence of his lawyer. In 2014, the Emirati Federal Council approved a new anti-terrorist law. This law is worrying because it is a potential threat to freedom of expression. The use of terrorism as a pretext for attacking opponents and repressing them makes us fear for the future. The death penalty is present in several articles of this law. When we look at several examples of this, we witness the difficulties of the justice system to function properly and the inability to pursue proper recourse. Hence, we call upon the Emirati authorities to immediately and unconditionally liberate all prisoners of conscience and political prisoners, including Dr. Hamid Mokhtar, to put an end to enforced disappearances and torture, and to sign the International Convention on the Protection of All Persons Against Enforced Disappearances, and to lift its reservations on Articles 20 and 22 of the Convention Against Torture and ratify the optional protocol thereto. Thank you.
National welcomes this opportunity to address Ms. Knowles' reports on Portugal, Qatar and the United Arab Emirates. We share the Special Rapporteur's concern that with growing poverty, access to justice in Portugal has been impaired due to the rise in costs of that access. This is of particular importance when the judiciary is called upon to assess the constitutionality of austerity measures affecting economic and social rights. In 2011, the Qatari government imprisoned poet Mohammed al-Ajami for the peaceful expression of his conscientiously held beliefs. He was convicted of breaking vaguely worded laws that did not constitute internationally recognizable criminal offences. Flagrant flaws in his trial were ignored. We call for his immediate and unconditional release. In 2010, Filipino migrant worker Ronaldo Lopez Ulep and 2 others were convicted of espionage following months of alleged torture. There must be a retrial. Since 2011, the United Arab Emirates authorities have mounted an unprecedented crackdown on freedom of expression, association and assembly. They have prosecuted over 100 activists in proceedings that failed to meet international fair trial standards. Vaguely worded laws severely limit the right to freedom of expression, association and assembly. The broad definitions of criminal offences in the 2014 counter-terror law are used to imprison activists or sentence them to death. The UAE's state security body continues to subject scores of UAE and foreign nationals to enforced disappearance in secret detention facilities, where torture and other ill treatment are rampant. Torture is often used to extract so-called confessions used to convict defendants in court. Harassment of human rights defenders continues. Academic and prominent human rights lawyer Dr. Mohammed Al-Rakin is serving a 10-year sentence following a mass trial of 94 activists. Activist Osama Al-Najjar is serving a 3-year sentence following secret detention, torture and questioning about his 2014 meeting with the Special Rapporteur.
Thank you.